Why don't we have one comment from Ilya? Go ahead.
This is an area where I disagree with a lot of my fellow libertarians and conservatives, because you often hear, especially in this forum, the 17th Amendment was awful, it destroyed federalism. In actuality, I think the 17th Amendment did no such thing for two reasons. One is, even before the enactment of the 17th Amendment, most states had already committed essentially to the popular election of senators. I think something like 38 or 39 of the then 48 states had already done so. Second, the argument implicitly assumes that popularly elected senators are somehow more likely to support federal government power than senators chosen by state legislatures. But given that, as I've said before, state legislatures actually like federal funds and often have reasons to support other expansions of federal power as well, it's by no means obvious to me that popularly elected senators, many of whom I agree are very bad people, are necessarily worse than senators selected by state legislatures, as the founders intended. There is an interaction here with the growth of the spending clause, its overexpansion, in that state governments did have an incentive to check federal power when increased federal spending necessarily meant less money for the states, when the federal government was believed not to have the power, for the most part, to subsidize state governments. But if the federal government can subsidize state governments, then that actually gives state governments an interest in increasing federal power. So if you're looking for judicially administrable standards for places where maybe extra scrutiny should be applied by the courts, I would argue one place to start is with federal spending that goes specifically to state governments, and therefore, for that reason, at least presumptively, is much less likely to be advancing general national interests as opposed to the interest of the particular state government in question.
Let me try over here.
Yes, this is a question primarily for Dean Eastman, although I'd welcome comments from any of the other panelists. You were the first among the panelists to raise the question about what exactly the Butler decision did, and I want to ask whether the following explanation makes sense to you and harmonizes the statements with the holding. And that is that the court adopted the Hamiltonian view of the spending power, and so it was not confining the spending power simply to the enumerated powers, but it was more broad. But the statute is struck down because of the taxing side of the equation. That is, a tax is levied and the money goes into a separate trust fund. It doesn't go into the general treasury. And so the court says if it doesn't go into the general treasury, for it to be validly considered a tax, it has to be, it's really a regulation that has to fit within one of the enumerated powers. And so they adopt Hamilton on the spending side, but more like Madison on the taxing side, and hold that you can't sever the statute.
I mean, that would bring some coherence to it. I mean, I don't find anything in the opinion to suggest that's what they're thinking. I think the better argument on how they claim to be adopting Hamilton's view and then strike it down for not furthering a purpose elsewhere enumerated, which is Madison's position, is that the general welfare clause itself encompasses some limit on purpose. And it's not just the other 17 clauses, but it is in the language general welfare itself. And so if you accept that, as I think even Hamilton did, that it has to be national, not local, and if it's not that, then it's not within the purpose given to the federal government, then I think you can reconcile it. They use kind of inartful language to do that, but I think that's ultimately what they meant, and it's the argument I've laid out as well. It's got to be national, not local, and it's not just is it going to be good for everybody in the aggregate. Obviously, education is good for everybody in the aggregate, or improved health care is good for everybody in the aggregate. But if you tie that with the routine pronouncements by the court that there's no general police power in the national government, and then when you start doing things that are police power-ish, the power to regulate the health, safety, welfare, or morals of the people, and that was reserved to the states. And when you start intruding on that, you've gone beyond general welfare and are now doing local police power type things that there's no authority in the national government to do. And I think that's an easier line. It would get us out of the education business at the national level, but not at the local level. It would get us out of the healthcare business. The reason people are more troubled by their federal taxes than their local taxes is because they're bigger. You know, but that's exactly what you want. You want the people who are most accountable for, you know, accomplishing the education or the healthcare ends to be the ones raising the taxes and tie back that benefit and the burden together, so you'll get less government and more efficient government. And that's the whole design, and we're toppling the whole design here in what we're doing.
I understand. I'm not
I'm gonna
contending with any of
Yeah.
that. My question was about a
Yeah.
reading of Butler.
Yep, no,
right.
thanks.
Thank you, over here.
Ron Rotunda from Chapman. A couple of the speakers said that, you know, the states can always turn down the money, but I don't think that can be much of a restraint, at least if Congress doesn't think it's much of a restraint. In the most recent, the $1 trillion stimulus bill that was passed, last January, February, has a provision that says that if the governor of the state doesn't want the money, that the state legislature can override the governor, not subject to the state veto. That is, the stimulus bill simply provided, no matter what state law is, even if the state constitution provides that the governor spends the money or could, that the state legislature just override that. I mean, that's a limit that the courts could easily enforce if there was somebody withstanding to bring it. There were, I think, 2 governors that turned it down. One was the fellow from, I think, South Carolina, but then he went on vacation to Venezuela or someplace. So, that's
Argentina, I think, yeah.
Argentina, whatever, he was gone. And I think Alaska turned it down, though they're the blue-eyed Arabs of the North and have so much money. But you think provisions like that where the government is really shoving it down your throat, because the point of that stimulus was, we're going to give you money now to dramatically increase your welfare rolls. That's what the provision provided. The money will stop in like 3 or 4 years, and then we figure by then it's going to be really hard to yank money from these poor people. And they were worried that the states would reject the money, so they just said states can't reject it.
Rick, do you want to try a stab at that?
Yeah, I read an article about that. That was soundly ignored. 1998. So, yeah, shameless self-promotion. It's called Dissecting the State, and it examines all the opinions that I could possibly find. In fact, I think I was cited by a dissent once, but yeah, you know, basically, I agree with you. That would obviously, I say that would be a flagrant violation of the Constitution. Federal law cannot override state constitutional mechanisms for registering collective consent. Where you get these laws, by the way, earlier was with the Indian Gaming Act. Yep. Which had this provision that said governors could take the money free from legislative appropriation. Where courts actually heard those cases, the New Mexico Supreme Court, for instance, they struck down that provision. They just said the governor cannot resist the state constitution. And I would assume that the same thing would apply here. That's an easy one for courts to enforce, and I'm sure that they would.
Kind of a twist on the anti-commandeering.
Yeah, it is the anti-commandeering rule, in my view.
All right, over here, and then we're going to take these last 2 questions after that. Go ahead.
Art Mackenber. It seems to be an analytical error to look at the General Welfare Clause or the Spending Clause from a perspective that removes the senators as being elected by state representatives, the state legislatures, as was designed. You know, in terms of, you know, guarding the hen house, if you will, trials for impeachment were done by the Senate. Advice and consent for judicial appointments was put in the Senate. And I'm wondering, from the panelists' point of view, and if Dean Eastman could begin, do you think, or to what extent do you think that it's an unintended consequence of the 17th Amendment that now we are becoming more reliant on the judiciary for interpretations of these clauses, as opposed to having the perspective of the Senate as appointed by state legislatures to help us define what these various clauses are?
Okay. Yeah, I mean, look, I think in the founders' theory on this, that having different modes of election and different terms in the Senate both provided a check on kind of the raw democratic passions that they expected the House of Representatives to exhibit. Neither of those turned out to be true. I mean, I think it's one of the singular errors in predictive consequence of their structure. You know, that the Senate, even in the days when they were chosen by the legislatures, ended up having a greater turnover than the House very quickly. I mean, you get this odd dynamic, and I don't think I think they thought there would be wholesale turning out of the House of Representatives every 2 years in a way that just didn't happen. So and then the political science literature that Ilya pointed out before, that the change may have actually gone the opposite way, that it may be more protective of individuals' interests in the states against a parochial view of the state legislatures that may have come out the other direction. So I'm not sure that check worked as it was envisioned, and so therefore I don't think the 17th Amendment made the impact that many people claim it did.